Donald Natcher. Is it Knatcher? How do you say your last name?
Knatcher.
Okay, 1 second. Come forward. Tell me how to say your last name.
Knatcher.
Okay, so we have a few things to discuss. You turned yourself in. Why didn't you just come here and see me?
Oh,
Why did you turn yourself into the jail?
I'm scared of the judges.
You're scared of judges?
Yeah.
Okay, your time served on your capias. Let's talk about those other charges that you let go to warrant. April 28th, 2024, driving while license is invalid. The fine range is $1 to $500. Court costs are $131. That charge comes with an extra consequence, plus the no insurance second. That further will suspend your license. On that charge from April 28th, 2024, do you want to plead not guilty because you want to hire an attorney or have a trial?
No contest.
On your no contest plea, finding court costs is $469, $300 jail credit. You still owe $169. To no insurance second, did you have insurance that day on that Ford F-150?
No, ma'am.
How do you choose to plead?
No contest.
Fine and court costs, that fine range I didn't tell you is $350 to $1,000. So fine and court costs total $733 with $300 jail credit. You owe $433 on that. So we're gonna have to talk about your balance, what you want to do. Operating a vehicle with an expired plate from April 30th, 2025 over on Eastern Street, same pickup. Not guilty, guilty or no contest.
No contest.
Fine and court cost is $242 on that one, your time served. Then expired driver's license, this officer was being nice to you. Fine range $1 to $200. Court costs are $131. How do you choose to plead?
No contest.
Fine and court cost is $260. Your time served on that. Still hurts your driving record though.
Yeah.
No liability insurance. That fine range, they filed it as a first, $175 to $350. Court costs are $131. How do you choose to plead?
No contest.
Okay, fine and court cost is $400, $300 jail credit. You owe $100. So let me tell you what your balance is. So I time served you on your capias. Let's see, is that all your charges? Yes. So $100 on this one plus $433 plus $169. You still owe $702. Now, if you'll come see me on Wednesday at 1:30 for a 2:00 hearing, but I don't want you driving that pickup down here.
Rather just set it out, ma'am.
Are you sure you want to do that? Because I would rather you come talk to me about community service because it's 5 more days starting tomorrow. Tuesday, Wednesday,
No way to
Thursday,
get around.
Friday, Saturday. Huh?
You got no way to get around. I'd rather just set it out.
Okay, you get out sometime Saturday. Are you sure?
Yes, ma'am.
It's a voluntary remand. The deputy in the back will have a form for you to sign. Just realize you're going to be there till Saturday. Now,
ma'am.
if you change your mind and you want to see me.
Honestly, that probably makes sense, but still, it's depressing as hell that that's your best option. By the way, this is you know, Law Nerds Unite and Lab Matt's fault. All this stuff.
Ahead of that Saturday release date, you tell your pod officer, okay?
Okay.
All right. Any questions, Mr. Knatcher?
No, ma'am.
Okay, thank you. You may return to your pod. Sign that form in the back, please.
All right. And Mr. Sabian, did you want to go back on the record with Mr. Keith's case?
Yes, yeah, it should be an SOC resolution, and I'm finishing typing it up right now and sending it to Mr. Sharp.
An SOC.
And Mr. Keith also has a hearing at the same time in room 2.
Okay.
Mr. Sabian, I wonder if you wouldn't mind sending it to the clerk. It's Kylie L today, and copy me.
That's right. Yeah.
Sending in a second.
Just in time. Okay, Mr. Keith, I have your stipulated order of continuance here. Have you reviewed that with Mr. Sabian?
Yes, sir, I have.
Okay, so you and the prosecuting attorney are agreeing to continue your case for the next 12 months without setting a trial date. During that 12 months, you have agreed to pay a monitoring fee, not violate the law, and not drive without a license and insurance, and to get a Washington driver's license. And if you do those things at the end of the 12-month continuance, then the prosecutor will dismiss the charge. All right, you're waiving your right to a speedy trial as part of this. You're also waiving your right to have a jury trial. So that means if the prosecutor proves that you violate any of the conditions that I just spelled out here, then you'll have a trial, but that'll be a judge-only trial without a jury. And the only evidence the judge will consider during your trial will be the police report submitted by the prosecutor. So do you have any questions at all about the rights you're waiving in order to take advantage of this?
No, sir.
Okay. Then I will accept your waivers and I'll accept your case for a 12-month continuance. All right. Any last minute questions about that before the hearing's over?
No, sir.
Okay, good luck on getting that driver's license. And I guess they need you over in the other courtroom.
Thank you, sir.
All right, thank you, Mr. Keith.
Your Honor, this is Mr. William Keith. His matters are 4th and 5th on the calendar.
Thank you.
He's here
Mr. Keith,
for-
good afternoon.
Good afternoon.
Your Honor, there is a motion for a 1077 evaluation that was sent earlier today by Mr. Stashevsky.
Okay. Do we have it, Janice?
No. 1077, I already did.
Okay.
They wouldn't release me until I did.
Yeah, Mr. Keith, I'll try to answer some of those questions here. I'm just reading through the document that I've been handed. So,
You know, this is going to come as a shock to you, but no, I don't.
just give me a couple minutes to get through that, okay? All right, I've reviewed the 1077, and it does seem appropriate to order a competency evaluation. Of course, the issue is going to be in custody or out of custody. I'll hear from Mr. Weston first. Mr. Weston, go ahead.
Thank you, Your Honor. Stay with the in custody matter. We asked for a no bail hold, I guess, pending the outcome of the 1077 or a sanction hearing or whatever happens first.
Actually, I believe both matters are still pretrial, aren't they? The DUI, I think it's still pretrial.
You are correct, Your Honor. So state was still asked for a warrant and asked for it to be in custody. These are old cases. State has substantial concerns about the safety of the community. Additionally, there's been that bench warrant out of Pacific County for about this, since 2021. So he's shown that he's not going to appear in person if that required.
Thank you. Ms. Vallejos?
Your Honor, I would request some sort of bail for Mr. Keith. I don't think he presents a danger to the community, as the state mentioned, but I do think an evaluation would be needed here.
I did the 1077 already.
I do. I get a real sense that he presents a danger to the community. I really do.
Your Honor. In Pacific County, they held me for almost a year. They wouldn't let me go until I did it. There's nothing wrong with my cognitive thought processing. There's nothing wrong with my cumulative thinking. There's nothing wrong with the way that I'm looking at things or perceiving things. There's nothing wrong with your perception of the way that I'm designing things. There's nothing wrong with my ability to understand things. They held me in jail for almost a year. I played God to please release me so I didn't die. I just need to take care of my health concerns. I'm doing the best I can. I'm sorry that I'm not rich, but I'm doing everything I possibly can. I'm being released on all of my other cases, and this is the only thing keeping me from getting a new heart.
Okay. All right. So your statement would indicate to me that 1077 may not be an appropriate route here because you seem basically fine to me. So do you know the charges you're here on?
No, sir, they weren't.
I actually agree with the judge. He seems fine with respect to 1077. But in terms of everyday functioning, he seems not fine at all. It sucks, but I think that's a fair assessment.
Weren't clearly explained to me, but I'm under the impression that there's some sort of an accumulated.
Okay, so let's talk about it a little bit. So you have the charge of driving under the influence of intoxicants, which is from 2021.
Yes, sir.
I think that really needs to be a term. Washington State normal, which means, yeah, not above committing crime, but but appreciates that he's committing crime.
It was explained, and I told them I didn't do it.
Okay, but everybody says they didn't do what they're charged with.
Yes,
I'm
sir.
just telling
I've been homeless with no vehicle for over 5 years. I've been in and out of jail because of it for the last 5 years. There's no possible way I could have done it.
Just let me talk a little bit, okay? And you just answer the questions I ask you. So you have a DUI from July 2nd of 2021. You have new charges, which are hit and run and driving suspended from February of 2022. So, within an 8-month period, you have those two Thurston County charges.
Okay, I've developed a theory on human psychology. I've never spent any time in Washington, although I did go to Vancouver, which is whatever. It's Canada, but it's close to Washington. So I get the drill. And here's what I think the deal is with human behavior. I do a lot of traveling. The nicer the environment, the crazier the average person. Not because they're really crazy, but they're just like, yeah. So if you're on a nice tropical island or in a beautiful, mountainous woods like Washington, it's just a lot of people just check out and absorb. Doesn't really make them bad, but it just attracts people who just want to float. I'm not even knocking it. It's just an observation. It's just something that happens.
All of which have yet to be resolved. And then you have a warrant out of Jefferson County from a driving charge in June of 2021. And I see that Olympia dismissed a charge, I'm assuming on competency grounds, in
Nailed it as usual, Andrew.
2022. So that's what we have. And then you have that active warrant. You've missed lots of hearings on the Thurston County cases. And then not only that, but once you're in custody, then you refuse to come. I know you refused twice last week to come to court.
No, sir. I was in custody last week, and they didn't come get me until they told me. I didn't refuse, sir. I came when I could.
Okay. Well, they told us you were refusing to come.
That's not true, Your Honor. I did the best that I could. I was begging for my chance.
This is getting awkward. I'm not going to lie.
We were having a hard time getting you to come to court, and we just can't let these cases sit out there until the stars align and we're here in court and you're here in court. It can't
I
work that
understand
way.
that. I don't want to waste your time, and I don't want you to waste mine.
Okay,
I understand that very much.
Do you understand the charges that you're here on?
Yeah, too late.
Yes, sir, I do.
Can you repeat them back to me?
The driving while license suspended, the DWI while license suspended in the third, and the DUI. Is that correct?
And a hit and run.
And a hit. Okay, that's.
Okay, do you understand those are the charges that you are?
Yes, sir. I
before the
understand
court
those are
on?
the charges, but I never did those things.
Right, okay, I understand that's what you're telling me. And do you understand what those charges are?
Yes, sir, I do.
Okay. Ms. Vallejo, since you're the one with the information on the 1077, let me ask you, is the conversation that Mr. Keith and I have just had, is that somehow substantively different than the one that you had with him as far as ability to understand?
It was, Your Honor.
Okay, and
I think
You didn't ask me any specific questions.
there was at a different emotional state than right now.
yeah, you're right. Okay, yeah, that's my guess here. I think Mr. Keith was probably expressing frustration. I'm not sure he was expressing lack of competency. So that's what I'm picking up here. So at this point, I'm not going to do the 1077. But Mr. Keith, with the inability to get you to come to court on any regular basis, I am going to hold you on some bail. It's not going to be a no bail hold, but I am going to hold you on some bail.
But I don't have money.
Yeah, I understand that. You've told me that. And I appreciate that this is going to make it difficult for you, but I can't let you go because when I let you go, you don't come back.
I do.
So-
I'm here again. I was just here last week.
That's because you get arrested.
No, because
All
I
right.
turned myself in last week.
Okay.
And I was
All right.
released.
Okay. Thank you, sir.
Yeah. When you're drug in there in cuffs and it doesn't count. That's not voluntary.
And I will note there's also a pending attempt to elude out of Pacific County. And I guess that's the one with the warrant outstanding. So it'll be $5,000 cash or bond on each case, and I'll set a new pretrial date. Thank you, Mr. Keith.
When is the new date?
Okay, sit tight and I'll tell you that in a minute. Have to get the form prepared. Ms. Bayos, is Mr. Stachewski counsel of record?
I am not certain that he's been assigned yet, Your Honor. He was just helping me with the evaluation.
Okay, all right. Well, for the record, I will appoint counsel to represent Mr. Keith if that hasn't been done before. So let's make sure we have counsel at his next hearing.
Sir, they have been releasing me on all the other cases so that I can get into the what is it? CHI Franciscan Rheumatology Cancer Ward to get my new heart. They've been releasing me on all the other cases so that I can get in there. I'm doing everything I can to prove it to you. Can you please give me a chance?
All right. Thank you. I've heard what you've had to say about that.
Your Honor,
So I'm going to set a pretrial hearing for Tuesday, the 2nd of December. I'll set it straight to the 1:30 calendar based on Mr. Keith saying he's not going to be able to post the bail in this case. And if the jail medical staff comes to the court with the request for furlough, we can certainly talk about that. But I'm just afraid we're going to get nowhere in this case if we keep doing what we've done in the past. All right, we'll see you on the 2nd of December. Thank you, Mr. Keith.
Along
Unmute. Mr. Seymour?
Yes, ma'am.
Okay, I want to be sure. You're not in the bed, are you?
I am sitting in my bed, yes, right now.
Can you get out of the bed? I don't want to do court with you in the bed. That's just creepy.
Dude, you're creeping us out. Stand up.
Okay, thank you. Are you sick?
No. Why?
Okay, well, because you were in the bed. It's 3:30 in the afternoon.
Oh, it's my day off. I work 12s as a nurse.
Okay, so
It's
yeah.
my day off, and that's where I
understand that. So the charge is called assault by contact family member. When we've seen you before, we've talked about, or you talked to Judge Hamilton, she gave you all those family violence warnings. What do we need to talk about today?
So I actually was just wanting to talk with the prosecutor. I went and saw discovery today. And frankly, I mean, one, there was no assault. And I am a nurse. I've been a nurse for 10 years. So is the other person that supposedly is involved. And we don't want anything on our records. We don't want anything messing with our licenses. I mean, we worked hard for all of this. I mean, and so basically I want it off my record. I mean, this is, I mean, I don't think it will cause any harm, but really, do you
It could. I think
want it to be on there, really, especially if you're a professional licensed person, you know? I don't want it.
Well, I know it would affect my bar card.
Yeah.
It would affect my license as an attorney. I know it would. It was for sure.
Okay, we've established you don't want the consequences of bad conduct. That doesn't mean the case goes away. We might be able to get rid of the case for other reasons. Maybe not, but we came into this with presumption that you want to avoid consequences. That's rational. That's rational human behavior. Good Lord.
Prevent me from being a judge. So I know it's a problem. I'm hoping that that's not Miss Herbert standing right there.
It is Miss Herbert standing right here, and I'm the one that will tell you.
Oh, wait, Miss Herbert, we're not ever going to discuss an assault by contact family member with the
Assault.
person.
If anyone assaulted anyone, I assaulted him.
Can I please?
Okay, so Miss Herbert, let me tell you, and I'm going to look at your bond. You had a cash bond.
Oh my God. What she's saying might even be right. Who knows? But this is not the time, place, or manner to make this particular argument. You can have this conversation with the prosecutor, but not during the freaking arraignment. Oh my God.
You bonded out. There's no restrictions on the bond. So Miss Eva is never going to
Convict.
Please stop.
Convict me. Send the cops to our address. They can arrest me.
Can you please stop and just hand me back my phone?
I am the person that punched him in the end. He was just trying to.
Okay.
Brian
So
is not
listen, I want you to listen to me, Miss Herbert. Miss Herbert, when you're involved in the legal system, this is the one thing about virtual court that I detest. People forget that we don't live our lives virtually. We're more like the hospital. You know, you telling me how to fix an illness virtually really isn't the best protocol because you're not seeing the whole thing.
But
And
not.
when there's an accusation and somebody got arrested and somebody went to jail, and it has to do with an assault, even a Class C assault, Miss Guerrero or even Miss Denholm, if she were here today, isn't going to talk to a victim and a defendant who are in the same room. And there's a lot of reasons for that, and those are all good reasons.
But ma'am, you're misunderstanding.
No.
I am not
Ashley.
a victim, as you said. I'm not a victim of domestic violence. If
Okay,
there's anything that I'm a victim
but you're not
of, I'm a
listening
victim
to,
of
you're not
emotion.
listening to what I said, Ms.
Ashley,
Herbert.
please just step away. This
Fine,
is
I'll
me
step
talking to her.
So, Mr. Seymour, I'm gonna leave it on that December 2nd docket.
Sure.
Ms. Herbert, if she needs to have a conversation with a prosecutor, then she needs to call the prosecutor's office and schedule an appointment. And at that appointment, you can't be there.
Right. And actually,
Your Honor, if I may, Ms. Herbert,
You'll have to cover,
non-prosecution.
you're glitching, so cover your video. Yeah, we can
Sorry,
hear.
Your Honor. So Ms. Herbert has filed an affidavit of non-prosecution with our office. She was told by Katie that does not mean that the prosecutor will dismiss the charges, but she will take it into consideration. This has not been set on a trial date yet, so it has not been assigned to a prosecutor. So there's not a prosecutor reviewing her affidavit as of yet.
Okay.
okay. And the only thing I really like, I didn't actually think I was talking to a judge today. I thought I was going to just speak with the prosecutor because I basically just want to know, is there enough to try and convict? And if so, do I need to have a lawyer? Because, I mean.
Well, let me give you a clue here, my friend. Prosecutors don't wear black robes. We do that for, on purpose. It's a little visual cue as to who you're talking to. So maybe, just maybe, stick with me now, you need to shut your hole.
I think this has been completely
Hamilton, you got it set for December 2nd to give some time to consult a lawyer. If you choose to do that, we're never going to say that's a bad idea. But I would also tell you that if you want to talk to a prosecutor in a virtual court setting like this, Ms. Herbert can't be there. Any conversations we have about this matter need to be with y'all not in the same building, because
Can I step outside?
no, because really it's not the prosecutor that's here today, it's the prosecutor's legal assistant.
Oh,
What
okay.
I would recommend that you do is leave it on December 2nd and ask for a virtual court setting on a time and date that Ms. Herbert's not there.
Get an attorney. Have the attorney call the prosecutor and discuss the whole thing. You can probably get rid of it. God knows what really happened. It might have been really nasty, and now she just wants to get rid of it because she doesn't want to see the household finances collapse. Or she could have really been full of crap to begin with and sort of cooked this up and now feels bad about it. I don't know. I don't know which one of those things it is. But the only way to get rid of this thing is to get an attorney. You can't handle it. Have the attorney contact the prosecutor and tell them what's going on.
Okay.
And because these things that happen in homes when police get called are always something that, it's dangerous for the police, it's dangerous for the individuals involved. So Ms. Herbert, we have your affidavit of non-prosecution. Ms. Guerrero said that it's in the file. And so leave it on December 2nd. Your December 2nd time is 9 a.m.
Okay.
And if you want to talk to a prosecutor, ask for another virtual walk-in. She just had an emergency, so she's not here today.
Okay.
If you want to speak to her in person, but
it hasn't been assigned yet. We don't know who the hell the prosecutor is. It's come out in this hearing. The only way to get rid of this case is to have the prosecutor review the affidavit and say, okay, probably talk to the alleged victim and make a call. That's the only way to get rid of this case right now. Otherwise, we're going forward. And that person doesn't exist yet because the file hasn't been assigned. It'll be somebody in the prosecutor's office. And then At that point, something can be done, not before. Period. End of statement.
I don't want to do that today because I know Ms. Herbert's there. Ms. Herbert can't be in the same, that any conversation that we would either have with Ms. Herbert or you need to be when neither of you are in the same place.
Okay, no.
How do I schedule one to let them know that the disgruntled ex that just tried to call a suicide attempt?
Stop.
Please.
Okay.
Okay, and so
I do it.
that's what I would recommend. So you're good, you're in good shape. Set it for December 2nd, and I'll be back here on December 2nd if you haven't resolved it beforehand, and then come into a virtual court setting when it can just be you.
Okay.
Okay, thank you. You're free to go.
Thank you.
Exciting and new.
Shit.
All right.
Watch out. Watch out. We've got production value. I assure you it's not my fault.
Let's go on the record.
You know who
In
did
the
you know
matter
who-
of, this one is over there. This is the one for the exam class. They are on the record in the matter of the State of Michigan versus Edmund Moss, 251225.
This is going to be good.
Good afternoon, Your Honor. I'm John Goldberg, the 3758 on behalf of Mr. Loss. Am I pronouncing your name correctly? Yes, sure. Thank you. Please put your name on the record.
My name is Edmund Moss.
All right, very good, thank you. And today is the date scheduled for the adjourned pretrial in this matter. And counsel?
Your Honor, I've had an opportunity to view the discovery, share that discovery with Mr. Moss, and also the audio of the phone calls. I've also had a lengthy discussion with the prosecuting attorney. It's my understanding that in return for a plea to attempt misuse of a telecommunications matter, a 93-day misdemeanor, the original charge of the vehicle. I have discussed this with Mr. Moss. We reviewed the word of the statute, which indicates that any person, if there's an alleged threat made, does not have to be one at the police department. And as such, at this point in time, he's asking that he wishes to enter into this plea opportunity.
Okay.
That's right.
Please raise your right hand. Do you solemnly swear or affirm testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth?
So I'll be happy to do.
Okay. And you heard the plea that was placed on the record by your attorney, correct?
Correct.
And you understand all of those, you understand the rights that you've gone over with your attorney as well?
I do.
And that by entering into a plea that you'll be waiving some of those rights?
I do.
As to the amended charge of attempt telecommunication service malicious use, how do you plead?
Guilty.
And you've also gone over the possible penalty as a result of your plea,
Correct.
whether in this court, any other court, or administrative agency.
Correct.
Knowing all of that, do you want to continue with your plea?
I do.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And any immigration issues? Counsel, if you can please pardon your client.
Thank you. Sir, back on July 3rd of 2025, did you make a telephone call to the Riverview Police Department?
I did.
And during that telephone call, did you threaten or make a statement that you would not your neighbor, Mr. I'm going to spell it.
Pellepori,
off of his bicycle?
I did.
And that was made by you, and you made that statement as a threatened assault or battery. Is that correct?
Correct.
I'm satisfied with that.
the court is also satisfied that the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement, and then there will be a pre-sentence investigation interview, as well as the sentencing date that you will receive from probation, and as well as some paperwork to complete regarding your pre-sentence interview.
Thank you, Your Honor.
Bond and conditions are continued. And we'll see you back at sentencing. So just have a seat over in probation. Somebody will be over shortly.
Thank you.
Thank you. We're on the record in the matter of the city of Riverview versus Edmund Moss, 251310. 251564.
Good afternoon, Your Honor. Blake, here on behalf of Edmund Moss. Mr. Moss, state your name.
Edmund Moss.
Okay, and good afternoon. And Mr. Carmen, your appearance, please, for the people. Mr. Carmen. While we're waiting for Mr. Carmen, counsel asks to the new matter, offense date of 11/4, 251564, ask the arraignment, counsel.
Plan waive formal reading, stand mute.
For waive formal reading, enter a plea of not guilty for purpose of the arraignment. And then as to the pretrial, counsel.
Your Honor, this file was just handed to me. I don't have a chance to even review police report.
The new file, the new case, I'm sorry, you mean the new case, counsel?
Be 1564.
Okay, well then we can recall this matter so you can have a chance to review.
Well, Your Honor, what we've discussed doing is we need to adjourn this to a pretrial, and I think we have discovery order on this as well.
Counsel, your appearance for the record, please.
Michael A. Carmen, 373824 on behalf of the firm. I'm sorry, prosecution.
Okay, so, Mr. Carmen, are the people intending to proceed with the bond violation as well? Since the allegations appear to be violating the bond this court set on 251310.
We are, Your Honor, yes. And I have Detective Haskins here for them.
Is the prosecutor sporting a lavender coat with a white tie, or is the color messed up on my thing? Wow.
So, Mr. Carmen, my question then is, did you file a written bond violation, counsel, or no?
Did not, Your Honor. This new case was just brought to my attention Friday, so no, have not.
Yeah, that makes it better. Pardon moi. It's pale plum.
All right, counsel, I'll see the two of you in chambers here.
Dan the chicken man, go and find that frying pan. Buck, 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 buck.
And there's my obnoxious neighbor's barking dog. And there's my obnoxious neighbor standing right there. What do you think I'm doing? Videotaping every time I'm my front yard? Yeah, I am. And you better get the fuck away from me. We're videotaping your neighbors. No, I'm going to videotape you. You deserve it. You're an asshole. You're a creep.
You're an asshole.
Taping your neighbors.
Yeah, and you and Carrie started, and I'm gonna finish it, asshole.
Finish it then.
I am.
Finish it. What are you gonna
This is finishing it. What are you gonna do?
Let's go to court.
We are
going to court?
We are going to court.
Where's my paperwork? Give me my paperwork.
You'll get it.
Yeah, bring it on. Let's go see the judge. Let's go see what she says about you. Fucking creep.
You're a fucking asshole.
You're a creep.
You're a fucking asshole.
Get a job. Move.
Yeah, bitch.
Pathetic.
You're a bitch.
You're a child.
You're the fucking man child.
Keep messing with me.
Yeah. What are you going to do? You threatening me?
Videotape my car some more.
Yeah, I will. Especially when they're parked too close to my driveway.
I'm too close to your driveway?
You know it.
Close to your driveway?
It is. I told you that.
Yeah. Go blow your nose.
Yeah. You're the piece of shit and get the fuck off my driveway, fucker. Oh, I'm going to be filming you. Especially when you're on my property.
This ain't your property.
Yes, it is.
Let this lady get by, you creep.
You're the fucking creep.
Don't cuss in front of people.
I'm not.
Don't do that because I.
What you gonna threaten me too?
Yeah, I'm gonna threaten you.
No, you're not gonna threaten. You're not gonna threaten. You're a piece of. I am gonna keep videotaping you.
What happens?
Yeah. What?
Yeah.
You keep threatening me.
Let's go see.
You want to keep threatening me?
Give me my paperwork. Let's go see the judge.
You will see the judge, and you'll see a jail cell again. I'm sure too, asshole.
He's out here filming my wife's car.
So what?
And that's doxing. And I'm going to teach you a lesson someday.
Yeah.
Not to dox people.
You're the one that needs to learn the lesson.
Bring it, James.
Yeah. I ain't your son.
Yeah, you're a delusional little punk.
No, you're not a doctor, and you're a fucking bitch who can't even fight his own battles because you got to have other people like her and like that other asshole fighting them for you.
Standing right here, swing, buddy.
I'm not going to swing. I'm not going to swing. I don't hit motherfuckers that wear glasses. Take your fucking glasses off, bitch.
You gonna swing?
You're going to have to throw the first punch because when you do, I'm going to throw 2, 3, 4, and 5, and you're going to end up in the hospital real fast. Besides that, I got a witness right there.
Yeah.
Okay. Yeah, that's right. Hey, Danny, you might want to witness this.
Stop, guys.
No, he doesn't stop. I'm not going to stop. Nope.
Momo, you watch out.
It's taking a while.
All right. Brownie hasn't seen this, Momo.
I know.
You
need therapy.
Yes, you're pathetic, and you ought to get yourself some therapy real fast.
My wife's cars.
Especially judging people you don't know.
I know you pretty good.
You don't know me at all.
I know your name.
Yeah, that's fine. Then you shouldn't be saying anything negative about me now, should you? Yeah.
It's easy to say negative stuff about you.
It's easy enough to say negative stuff about you because you're a fucking piece of shit. And I'm gonna flush you right down the fucking toilet of life.
Out here.
Yeah. I'm not gonna stop cussing. You cuss. You're a fucking asshole. Cussed all the time. You better be careful of the company you keep. You're going to go down with the ship one of these days. Yeah. And your buddy Swift ain't always going to be there to protect you. It will be the day. He ain't always going to be there to protect your ass. I'd have hit you long ago, but you ain't fucking worth it. You're so pathetic. You got to hide behind your wife and that.
I'm out here in my front yard. I'm not hiding behind nobody.
Well, I'm glad you're admitting that's your front yard right there, and that's your grass. About time. And so is that. You ought to cut it too.
Don't be filming your neighbors.
I'm gonna film you. I'm gonna film you every time you come out. I'm gonna be filming.
It makes you look delusional.
You know what? You can't speak for anybody else besides yourself.
You posted 100 videos.
I probably posted more than that. I probably posted more than that. No, I posted and starting. No, you have the problem.
You're the ones.
No. YouTubers don't agree with you on that. They just don't agree with you. And you're losing support all the time, and you know it.
I don't need any support.
Yeah, you do. You got to have other people fight your battles for you. And the last time, oh, yeah, sure they are.
I'm right.
Sure they are.
I'm right.
And then I'm right here, and I'm not going anywhere.
Get out of my way. I'm walking this way.
Yep. Oh, you just touched me.
My brain isn't functioning. Anything. Okay, let's go on about third in the matter of the city of Riverview versus Edmund Moss, 251564, 251310. Council?
Michael A. Carmen, 734.
Oh, that was all Zach over at Law Nerds Unite. I don't know where he got that, but that was fun.
Prosecution.
Thank you.
Ron Neal, we'll here on behalf of Edmund Moss. Mr. Moss, please state your name.
Edmund Moss. All right, thank you, and good afternoon. And so we did have an in-chambers conference, council, as to this matter and the continued I don't even know what to describe it, what to label it. The continued utilization of resources, I don't know, that continue to occur because Mr. Moss and Mr. Calipori can't get along. And so we did have an in-chambers conference. And then Mr. DeBlois had not yet seen the new case that was up for arraignment today, alleging some facts from November 4th and possibly November 5th. And so then, Council, Mr. DeBlois, you had an opportunity to review those, correct?
Yes, Your Honor. As I understand it, there's three matters. Essentially, we've got 251310, which is pre-trial. That was adjourned for discovery. The new matter is set for arraignment today. We're prepared to have Mr. Moss arraigned, and I think the understanding here is that those two cases would be adjourned, so I get the discovery on the second matter, and then we're hopefully coming up with some sort of a global resolution of those two matters. In addition to that, there are new allegations with respect to an alleged bond violation, which we're not prepared to address today.
Correct. All right. But I'm also not able to put this all the way out till December 15th. So is there another date? I know that on the 24th you're coming back on November, but I think that might be too early. Can you come back on December 1st, Council? Or maybe we can have everybody come back on an afternoon on a Tuesday, since that'll be after your Inkster docket, Mr. Carmen. Mr. Boyd, I don't know if you can come on a Tuesday afternoon.
Depends on the Tuesday, Judge.
Correct. So
the first option was December 1st. This was your suggestion?
yes, but I think that may not have worked for you on a prior case, so I don't know if that is still the case.
I think the 24th would be fine. For you, Mr. DeBlois.
No, the 24th. The 24th, I don't think is going to be enough time for the discovery on both cases. So, I mean, unless you think that it is.
I would think so.
But Mr. DeBlois isn't here in person that day. Because he has a probate matter. And I set a matter where I permitted him to appear via Zoom on that matter. And that was set for November 24th. So, and this is too difficult of a matter to have Mr. DeBlois via Zoom and Mr. Moss in person. So the 24th is not going to work. How is Tuesday, December 2nd?
I can come in for that if I have to, yes.
The 20th, if we could do the 25th in the afternoon, that would actually be better. But the second is.
Yes, the second, please.
That works.
You're blocked in the afternoon.
I am. Well, let's see why that is. Oh, because we have a joint management meeting at 2:00. We can do 1:00.
On the second, I'm free in the morning, if that's.
Mr. DeBlois, Mr. Carmen's not free in the morning, I don't think.
I'm available all day. So
1:00 works.
What time is it?
1:00. All right, so we'll adjourn for discovery December 2nd at 1 p.m. So I'll have to have Angela unblock that. And I didn't see a discovery order in here. Oh, no, I did. I saw it on one case. I saw it on only the new one. You also have it on, oh, I already signed this one on October 27th on the other matter. Oh, I have to sign all those, Terry. I'm sorry. Okay. So, all right, then, as to bond on the new matter.
Your Honor, we would ask that similar condition as the last case be put in place, no calls to the police department, absent medical emergency, and no to Mayor Swift or anything regarding Daniel Telefori, who was a protected individual under the current condition.
Mr. DuBois?
Your Honor, I think that's reasonable. But we would concur in there.
So, Mr. Moss, there's the allegation on the new matter. One of the allegations, sir, is that you contacted the police department, which is a violation of the bond condition on the 251310 matter. I understand that your attorney is not prepared to address that today because there has not been a bond violation or a motion for bond violation or otherwise submitted by the prosecution. However, the court does need to take that into consideration in assessing bond and conditions in this matter.
If I may,
Yes.
without getting into the facts that was just presented to me today, I've had a chance to fully investigate, but just from the record provided, it looks like an inadvertent hang-up call. That's all. And he didn't call, threaten anybody. There's no communication involved, if in fact that was a call from him. So it's de minimis at worst. And so I don't think that should carry much weight in terms of setting bond conditions. He understands he's not supposed to call the police. He now understands he's not supposed to call the mayor either. So he won't do that. But as far as putting additional restrictions beyond that, my feeling is isn't warranted. They can't really put him on the stand and have him testify to anything at the moment.
No, I understand that, and I can appreciate your advocacy, Mr. DeBlois. The court will also note with Mr. Moss's history that, and given that he, up until this allegation, seems to have been compliant with bond, the inadvertent hang-up will be an interesting defense to hear at the bond violation hearing, if there is one. Mr. Moss, I gotta tell you, I think I'm kind of fresh out of ideas with you. Fresh out of ideas with you. If you don't like your neighbor's barking dogs, wear earplugs. Or headphones. Listen to music. Whatever it may be. Or move. You can relocate. You have the freedom to relocate, sir. But if your neighbor's standing in the street, who cares? Who cares? If the dogs are barking, who cares? Dogs bark. They bark. They bark at a bird. They bark at somebody walking down the street. They may bark if they see a leaf falling. Who knows? Who cares? If you don't like it, put some earplugs in. You don't pick up the phone and call anybody to threaten anything or otherwise. Am I clear on that?
Understood.
So now what this court's going to do is this court is going to restrict you from contacting the mayor's office or any other offices within the city of Riverview. Unless there is a life and death medical emergency. Is that clear, Mr. Moss?
It is.
The pettiness is absolutely at an all-time low. Well, no, I think that was the last time with the tree bark. That was the all-time low. You're not to have any contact with Mayor Swift or any other City of Riverview employee or contractor. You're not to enter the premises at any City of Riverview property. Aren't you tired of coming to court, sir?
How long since have been? Yes.
Yes, I mean, you're more than welcome to come in and visit anytime you'd like. You don't have to come in here every time just because you don't have to get in trouble just to come into court. The court's going to order a $7,500 personal bond. If there is any sort of violation of this bond, sir, that will be converted to a cash bond. And we may see you back sooner if the prosecution files a motion regarding bond violation. I don't know. But just be prepared that that could be before the December 2nd date, if that's what is requested. Anything else?
Nothing further, Your Honor. That's good.
Have a good day.
Thank you.
All right, off the record.
I give him a copy of this.
All right. This one's getting good. This one's heating up. I got to see the next appearances. Deep thoughts with DeSanto.
Now calling the people of the state of Michigan versus Jermaine Malik Mangum, police agency report number 25-79.
And we get a little palate cleanser. Also Lab Matt's fault and Brecken.
9244. Can I have appearances for the record, please?
Yes, Your Honor. Katie Rusmersky for the people.
And Laura Yagi, Assistant Public Defender, requesting appointment with and on behalf of Mr. Mangum.
And Attorney Yagi, do you want to address the plea?
Yes, we would stand mute. However, unfortunately, I didn't have the complaint, so I would ask the court for a formal reading at this time of the charge. Thank you.
So what I have here is a misdemeanor complaint that charges that on or about November 10th, 2025, at Mr. Mangum, you did assault or assault and batter Nevaeh Bankston, an individual with whom you have a dating relationship. This is otherwise known as domestic violence. You understand the charge against you?
Against me?
Yes.
Yeah, I understand.
This is, as I stated, a misdemeanor. It has a maximum potential penalty of up to
Yeah, you dummy.
93 days in jail, a $500 fine, plus court costs for both. Do you understand all of that?
Yeah, I understand.
Thank you. And I meant to say that if that last part doesn't apply to you, then you don't have to worry about it. So,
Okay.
all right. So, and this is a misdemeanor charge, and it is actually a 14-week case. There will be a pretrial conference date scheduled for November 17th, 2025. That will be at 9 in the morning in front of Judge Washington. So, do the attorneys want to address bond?
Your Honor, the court, I would imagine, is in receipt of the bond form that I filled out this morning. I authorized these charges. My request is I'm sorry, Your Honor.
I don't have the bond form.
Well, apologies. Our system is a newer system, so it could be user error or it could be system error.
It's me. I was looking in OnBase and I have it here in print. So never mind. I am in receipt. Thank you.
No, you're welcome. I'm just always grateful when it's not me. Your Honor, I've requested a $5,000 cash bond. I understand we're dealing with a misdemeanor, but it is a domestic violence misdemeanor. I was taken by the fact that this was called in by a neighbor, and the victim in this matter was described in the report as very, very afraid. The neighbor called it in because the assault was loud enough that it sounded to her like he was beating her ass, air quotes. The victim indicated that the defendant, during the period of time of the assault, threatened to slap the F out of her, picked her up and threw her down at least twice, once on the bed and once on the floor. She hit an object with her head in the event where he was throwing her on the floor. Judge, I just think Your Honor, I think it's a serious situation. I think for the protection, the safety of the victim and the public, that is the reason for the $5,000 cash request. Certainly, I would also ask for standard domestic violence bond conditions, or what I consider to be those no go to and no contact with the victim in any manner. I would note that there is a criminal history. It is certainly from 2012, but it is to me a concerning criminal history in that it's an armed robbery felony firearm conviction. So we have some connection to weapons as well. I see on the criminal history that there is a domestic violence charge that was dismissed as of Halloween of this year. Again, I don't know if it's because it's a new system and or again user error, or if it's because it's a charge that stems elsewhere, like perhaps city attorney, but I can't pull anything up pertaining to that other charge, but that is also of concern to me as well. I think that's all I have to say about that request. Happy to answer questions if you need me to.
Thank you. Attorney Yagi?
Thank you, Your Honor. We would request a personal bond with the standard conditions. Even though I didn't have the complaint, I did discuss with Mr. Mangum the standard conditions for a DV case, so he does understand those. My understanding is the complaining witness and Mr. Mangum do have separate residences, so we did discuss that if there was any concern about that, and he said he is an entirely separate residence, so he would, if he is able to be released, he would be able to completely avoid not having any contact with her whatsoever. My understanding is also she is not the mother of his children, so there's even no need for them to have contact in terms of the children. He is gainfully employed as a landscaper, so he does work in the community. My understanding is he's not on probation or parole. I did see 2 cases that were traffic cases that were pending, but I didn't see anything else that was indicated a risk to the community in terms of anything else pending against him. So I would ask for the standard conditions. If the court is considering a cash bond, I would ask maybe for the court to consider some other assurance besides a cash bond, such as maybe a tracking tether or reporting to community corrections in lieu of a cash bond that would provide additional supervision or security for the community rather than a cash bond. Thank you, Your Honor.
Attorney Yagi, it sounds like we might not have gotten a CAA form for Mr. Mangum.
I apologize about that. I'll send it right now. Sorry, Your Honor.
The court will set bond with the following conditions. Mr. Mangum, you are not to use or possess alcohol, marijuana, or illegal drugs. Within 24 hours of your release, you are to report to community corrections for drug and alcohol testing. You will need $12 and a photo ID. You are not to purchase or possess any firearms, ammunition, other dangerous weapons, or the means to create them. Any weapons that you do possess are to be surrendered. You are not to leave the state of Michigan without the court's permission. You are not to have contact with Nevaeh Bankston. When the court says no contact, what the court means is no in-person contact, no contact through the mail, no contact over the computer or phone via phone calls, text messages, emails, social media, the internet in any way, shape, or form, or through third parties. You are not to go to when the court says do not go, the court does not care. If you own a place, rent a place, or are personally invited to go to a place, do not go. If you have anything that you have to collect from there, you may do that on a civil standby. Otherwise, prior to your release, you are to be fitted with a GPS tether with a hot zone of that address. You are not to engage in any sort of assaultive, threatening, harassing, terrorizing, molesting, or stalking behaviors towards Ms. Bankston or anyone else. You are not to engage in any sort of criminal activity whatsoever. You are to appear for any and all dates set for you by the court. The next one in this matter being that November 17th, 2025, court date at 9 a.m. in front of Judge Washington. That also means going to community corrections as directed. Do you have any questions about the bond conditions?
Yeah. You said I gotta go to community corrections and get a tether? That's what you said?
No, I said you're to be fitted with a tether prior to your release.
So what that mean? I mean I gotta get put on tether before I leave?
Yes.
Do it still be today? Or is it a certain day?
Well, let me finish.
Oh, okay.
These conditions will be entered into the Law Enforcement Information Network. They will be readily accessible to any police officers that you may come into contact with. If they have probable cause to believe that you have violated one of these conditions, then a bench warrant they can arrest you on the spot, and you'll be held for a bond violation hearing date in front of a judge who may revoke your bond and set a new, more restrictive one. At this time, the court will set bond in the amount of $15,000. 10% is allowed. Anything else from the attorneys?
No, thank you.
No, thank you.
Mangum, you are free to go to the door and tell the jail that you are finished.
What happened though? What is I'm getting out or?
Bond is set at $15,000. 10% is allowed, so you can post $1,500 to get out.
Oh, I gotta pay $1,500?
Yes.
What do I pay it at though?
Have a conversation with your public defender about this, please.
Well, the jail will tell you specifics. Unfortunately, I don't know how they pay it, but the jail will be able to help you, sir. So you can ask them, okay?
So I got one more question. So when I pay, will I be able to get out the same day or will I have to wait or y'all know? Anybody know?
I
I read that as so how long till I can do it again?
I truly don't know because today is Veterans Day. I don't know if they will come put a tether on you today. I really don't know. It's been a while since I've worked on a holiday. So I truly don't know, but ask the jail.
It is Veterans Day, and before I forget, I don't want to. I plan to, but I don't want to forget. So thank you to all of our veterans.
They should be able to tell you.
Okay. All right.
Thank you. You are free to go to the door.
So, all right. One more question. One more question. So 15,000, 10%, that's 5,000, right?
It's 1,500,
Oh,
1,500.
all right. All right. And I gotta get a tether. It ain't no way around it.
Correct.
But y'all don't know if it could get put on today or not. If I post bond.
No, as Attorney Yagi said, it's a holiday, so I don't know if community corrections is open today.
All right.
All right. All right. I don't know if that was much of a palate cleanser. Good stuff. Thank you so much, Brecken and Zach, for hooking me up. That was good stuff. I was worried about today. I'm like, you know, figure it would be a light court date for good reason, for very good reason. But we had a lot of good material there. Thank y'all for coming out. I appreciate it. Thank you, veterans, again. I will see you all soon.